ऐश्वर्यस्य विभूषणं सुजनता शौर्यस्य वाक्संयमो ज्ञानस्योपशमः श्रुतस्य विनयो वित्तस्य पात्रे व्ययः अक्रोधस्तपस्तक्षमा प्रभवितो धर्मस्य निर्व्याजता सर्वेषामपि सर्वकारणमिदं शीलं परं भूषणम् असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्योर्मामृतङ्गमय ॐ शान्ति शान्ति शान्तिः.
Very good morning to all of you. Hope you are all doing great. So today will be your final show of legal logical reasoning. This is legal aptitude final class. So in today's class, the coverage will be balance whatever is left out in the Contract Act, Law of Torts, and Company Secretary legislation. So we will be discussing completely from your exam perspective, CSEET perspective. So major of the important points will be discussed with you. I hope it is very clear with respect to all the concepts that are covered till now. Whatever the concepts is that are covered, I hope all are clear. So going ahead with my discussion. Yesterday I stopped at consideration. Yesterday our discussion was stopped at consideration. We discussed what is contract, what are the essential elements of a contract. So to make a contract, we said there is a requirement for agreement and enforceability under law. Enforceability under law was easily explained. Then we understood what is agreement. For agreement, there was requirement of two things. One is basically presence of more than two people, more than one person, that is two or more persons. And consensus ad idem was important. That is what we discussed. After that, we said that in order to constitute agreement, there should be an offer and there should be an acceptance. Once offer is accepted, that will be called as a promise. Then we discussed what are the essential elements of an offer, what are the essential elements of an acceptance, communication of offer and acceptance. Then we understood that what is consideration. Then we focused on what is consideration. So with this, majority of the topics were covered yesterday. In today's class, we'll be discussing on free consent, because one of the essential element of valid contract says, yesterday we saw essentials of valid contract, out of which one point was genuine consent. That means it should not be a forced consent. It should not be a manipulated consent. It should not be a biased consent. It should not be out of force. It should not be out of some influence. So the person, when he is giving consent for entering into a contract, it should be free from each and everything. Legally, it should be free. For that purpose, we discussed something called as genuine consent. So in today's class, we'll understand what is this free consent all about. What will be considered as a free consent. Section 14 of the Act, Indian Contract Act. Section 14. So tell me, which year Indian Contract Act came into force? What is the year of Indian Contract Act? Can I get an answer there? 1st September 1872 is the year in which Contract Act was brought into force. Yes. 1st September 1872 is the year in which Contract Act was brought into force. So based on that, our discussion is going on. Section 14 of the Contract Act says, consent is said to be free when it is not caused by. A consent is said to be free When it is not caused by, that means if these things are not there, the consent is free consent. If these things are there, then consent is not free consent. So consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or a mistake. So to call it a free consent, there should not be coercion causing the consent. There should not be undue influence causing the consent. There should not be any fraud that has caused the consent. There should not be any misrepresentation that has caused consent, or there should not be any mistake as to consent. With respect to these 3 points, with respect to coercion, these 4 points, coercion, undue influence, fraud, and misrepresentation, if at all a contract is entered under these conditions, you will say the consent is not free anyhow, and the contract becomes voidable. The contract becomes voidable. Sir, what is voidable? Void means those contracts which cannot be exercised in the court of law, which cannot be exercised at all. Those are void contracts. See, void contracts are of 2 types. When I speak about void contracts, they are of 2 types. More than void contracts, I can say void agreements are of 2 types. Void agreements are of 2 types. So what are they? Let us understand once. Sir, why are you saying agreement rather than contract? See, if you know at the very beginning of entering into a contract that contract cannot be exercised as per the law, entering into a contract with minor, entering into a contract with unsound person, then there are some other contracts which I'll be telling you later, wager, or maybe agreement in restraint of marriage, agreement in restraint of a trade, agreement in restraint of parental rights. When you are entering into these type of contracts, the law says no, these contracts are not valid at all. Law expressly says that these contracts are not valid at all. So when law is saying this is not a contract, when law itself is saying this is not a contract, how will you call it as a contract? You cannot call it as a contract because there is no enforceability by law. You'll be calling it as void agreements. But there are some type of contracts which at the time of entering into a contract are valid. Later on they become void. Such type of contracts are called as void contracts. They become void due to such condition where you are not able to perform it due to various situations. We call this as frustration. Due to the effect of frustration, you cannot undertake the contract. Such contracts are called as void contract itself. That means at the time of entering into a contract, they are valid. Later on, they become void. Later on, they become impossible or void. In between them, there is something called as voidable. So this is voidable. Voidable means what? There is an ability to cancel the contract, to make the contract void. So this is an able. There is a chance. Either you can make the contract valid or you can say the contract is void. So this type of contracts are called as voidable. So what is voidable? Where a consent to the contract is not free, the contract becomes voidable. That means if A enters into contract with B under any of these circumstances, it may be due to coercion, it may be due to undue influence, it may be due to misrepresentation, or maybe due to fraud. A has an option to cancel the contract. The innocent party has the option to cancel the contract. Such a contract is called as voidable contracts. So I repeat, when contract becomes voidable, or when contract is entered not due to a free consent, in the absence of free consent, the innocent party who has entered into a contract, who was made to enter into a contract, has an option to exercise, to cancel the contract. Such type of contracts are called as voidable contracts. If contracts are not cancelled, it becomes a valid contract. If contracts are cancelled, it becomes void contract. So voidable is a mid position where a person has the capability to cancel the contracts. When contract becomes voidable, it is usually at the option of party who has given his consent to cancel the contract. So here A has the option to cancel the contract. A has the option to cancel the contract. So going on ahead, coercion. Let us understand one by one coercion, undue influence, fraud, and misrepresentation. What is coercion? You can see the image there. Someone is holding gunpoint. Someone is making to sign the contract on a gunpoint. That means someone is doing an act which is prohibited, forbidden by Indian Penal Code. Threatening to do something or doing something to enter into, make the other person enter into a contract. So I have seen a very good house, villa. There is a villa in my locality. At no matter what, I want that villa to be mine. No matter what, I want that villa to be mine. I try to negotiate with those people. They say, no, we are not going to sell it. Now what I will do? I will take a gun, or I will threaten them to kill them, or I'll threaten to kidnap some person and then enter into a contract. Now what happens? The contract which is happening between me and them are voidable. That means they can cancel the contract. They can go to the court of law and say, sir, this contract is not a free consented contract. He used the force on us. That is why we want to cancel this contract. Such type of contracts are called as voidable contracts. Such type of contracts are called as voidable contracts. A contract is said to be caused by coercion when it is obtained by committing any act forbidden by Indian Penal Code. Indian Penal Code, those acts which are said not to be done, maybe murder, maybe theft, maybe kidnapping, maybe assault, or anything like that, or threatening to commit such an act. So here he is actually threatening. He is not killing. He is actually threatening. He is showing the gun point and telling, I may kill you if you don't enter into a contract. Such type of contracts are said to be entered due to coercion. Unlawful detaining of property. So now I see a beautiful car in the parking lot. I see a beautiful car in the parking lot, which belongs to Mr. Z. Which belongs to Mr. Z. Now what I will do is, somehow I'll break into the car and I will get the control of the car. I'll get the control of the car and I take it to unknown location. I call to Mr. Z. Hello, Mr. Z. This is Mr. Y here. Don Mr. Y. See, I am liking your car. I want your car. No matter what, I'll not be returning your car. If you want, I'll give 50,000 rupees. That's it. I'll give you 50,000 rupees, but I'll not return the car. What to do? Car is gone. At least 50,000 he will get. Z will agree. Then he will go to the court of law and file a case against me. Says, this contract is not a valid contract. He made to enter me because he detained my property, or threatening to detain. I'll call and say, see, I have noted your son there. I have noted your son there. So your son is walking there. If you don't sell your home to me, I will kidnap him. I'll kidnap him. Or some property, I'll take that away. Some jewels or something like that. This is called as coercion. So coercion means what? External force, an act threatening to commit or acting on those acts which are forbidden by Indian Penal Code. Those acts which are forbidden by Indian Penal Code. That is coercion. Simple. The next one is undue influence. So you can see, mom is making the son to enter into a contract. Mom is forcing the son. Undue influence is all about positions. Remember, keywords for coercion. What is the keyword? For act forbidden by Indian Penal Code. For coercion, you can match like this. For coercion, crime, criminal activity, crime, CC, crime. For undue influence, you can use the word position. You can use the word position. Here there is a position, there is a relationship between the parties. A contract is said to be induced by undue influence, where a relationship between the parties is such that one can dominate the others. So the relationship between parties is such that one party can dominate the other party. Sir, where such type of this thing you can see? Parents and son, parents and children. Parents will be in the dominating position. So if parents are forcing the children to enter into a contract, then obviously it will be caused due to undue influence. Teacher students, even in this case, it is undue influence. Even in this case, it is undue influence. A lawyer and his client, an advocate and his client, It is also undue influence. Why? If such contracts are entered, because all the confidential information will be with the lawyer, so the advocate. So that is why advocate and client. Hitesh is telling master and student. Very good. Master, so yeah, teacher and student. I said master and servant. Master and servant. So master can threaten. I may remove you. If you don't do this thing, I'll be taking you out of the job. Yes. Income tax officer and SSC. Income tax officer and SSC. Income tax officer may threaten. See, if you don't want to pay the penalty, I want you to give me this. I want you to sell your house to me. I want you to sell this property to me. So even in this case, it is undue influence. So what is this? If there is no relationship and something is happening, it cannot be called as an undue influence. To call an undue influence, there should be a relationship between the parties. Relationship need not be family relationship. Relationship can be of anything. So a doctor and a patient is also relationship, because doctor will be in dominating position. Otherwise, doctor will say, see, if you don't do these things, I will kill you, or I will make something so that you will be losing your some parts or something like that. You will be losing your eyesight or something like that. So this can be done. Dominating party uses such position to obtain unfair advantage. Dominating party should use such position to take unfair advantage. So this is what undue influence is all about. Is that clear for you? Shall I proceed? Yes. If you're clear, please do tell me. Shall I proceed? Yes. Next is a fraud. You say, is a big fraud, man. Fraud means what? Fraud means actually committing something which is not favorable, So what I can say, contract is made to enter under following circumstances, suggestion as to fact which is not true by one who does not believe it to be true. Simply saying, this sentence is slightly confusing. We can just decode it like this. Okay, I'll show this example only. Let us say he is a car dealer. This person is a car dealer. He wants to sell this car. Customer has come to him. Customer is saying, I want a car which gives 25 kilometer per liter mileage. 25 per kilometer mileage. I want a car which gives 25 kilometer mileage, 25 kilometer per liter mileage. Now this person actually knows that this car won't give 25 kilometer per liter. He knows that the maximum mileage this car gives is 18 kilometer per liter. Still he sells it. Still he makes the contract. In this case, this person is said to be committed fraud. This person is said to have committed fraud. So what is the saying actually? Suggestion as to fact which is not true, but one who does it not believes it to be true. That means the person doing it also knows that it is not true. That means a person knowing that a fact is not true, makes the other person to believe it as true. That is what you say as fraud, right? So people will say, we will double your money in 2 weeks. Yeah, this who's our Hera Fairy. If you see the Hera Fairy movie, one lady comes and says, we'll be doubling your money in 1 month. We'll be doubling you just pay us 50 lakh rupees. We'll be giving you 1 crore rupees back. So Akshay Kumar comes into a trap. Now the lady who is making the contract knows very well that this is a fake. This is not possible. We cannot do this. Knowingly she makes a false statement. It is called as fraud. That is called as fraud. So one of the example for fraud is that. Next one, active concealment of facts by one having the knowledge of it. So you are a furniture dealer who are selling different chairs. You know there is a broken chair. You fix it in a temporary way so that once it goes to client's house, again it will be broken. You fix it temporarily, but you conceal this fact. You won't tell this fact to your client or your customer. Your customer later on comes to know. This will amount to fraud because you are actively concealing, hiding something. This amounts to fraud. A promise made without any intention to perform. So you go to a shop to purchase some goods and say you will be paying after 10 days. But you, in your mind, you know that you will never be paying him. You will be a fraud. You will be called as a fraud. The contract entered will be a fraud. The contract entered will be a fraud. Any act which law declares as fraud. So tomorrow, if law is declaring such and such activity is fraud, then such an entry, the contracts which are entered under such circumstances will be called as fraud. So fraud is all about intentional. Fraud is intentional. Intention to cheat other person is called as fraud. You have the intention to cheat the other person. That is what we say mens rea, right? Not exactly mens rea. Mens rea comes in criminal mindset. Criminal mindset. In your thoughts it comes. But here there is an intention. For the purpose of intention, I said that word. So intention is there to cheat other person, to hide the facts from him, to not to reveal the reality, to not to reveal the truth. That is called as fraud. That is called as fraud. In similar line, we have something called as misrepresentation. So misrepresentation means what? How misrepresentation is different from fraud? We need to understand. See, misrepresentation means you are not aware of the fact, but still you assert it. So now same example, same car example I will take. The seller of the car is not aware what is the maximum mileage of this car. He is not aware. In previous case, I said he is aware that it runs only for 18 kilometers. But here he is not aware at all. He is not aware what is the mileage. This person comes and says he wants for 25 per kilometer mileage. And he says, yes, among many features, this gives a good mileage. That's it, he says. This gives a good mileage. When he says 25 kilometers, whether it gives 25 kilometers, he says, yes, he asserts it. He asserts it. He says, yes, positive assertion of a fact, which is true, though the person making, which is not true, though person making it believes it to be true. Here he is believing, his belief is important. The person making the assertions belief is important. Here he is not believing. In case of fraud, he is not believing that it is true. Even he is not believing, but he is making other person to believe. But here he doesn't know. First of all, he doesn't know. He is not aware of the fact, but still he makes the other person to believe it. In this case, this will amount to misrepresentation. Both fraud and misrepresentation are voidable contracts only. It is left to the option of this person. Either he can cancel the contract or he can continue with the contract. Yes. Any breach of duty. So you are given with some duty and you are not performing it. Even that will be amounting to, or you are showing yourself as in higher position. You are given with some duty, but you are showing yourself in a higher position. That will amount to misrepresentation. Costing mistake as to substance of thing which is subject to agreement. So you are going to sell a new car. You know there is a scratch in it. You try to hide the scratch temporarily. Now this will amount to misrepresentation. You are representing the things wrongly. So these are nothing but fraud and misrepresentation, which are in same lines, but fraud is intentional, misrepresentation is unintentional. Misrepresentation is unintentional. In both the cases, the contract will be voidable. Now, next question comes, does silence amount to fraud? So, you are selling a horse. You are into a horse trade. You are selling a horse. You are entering into a contract to sell your horse. Your horse is ill, but you are silent about it. Will it amount to fraud is the question. The law says, by default, silence will not amount to fraud. By default, silence will not amount to fraud. It is the duty of the buyer to be careful. To make the inquiry. But there are certain circumstances where silence will be considered as a fraud. Which are they? Such conditions are called as uberime fide. Contracts which requires uberime fide. Contracts which are required to be entered in uberime fide. Sir, what is uberime fide? Utmost good faith. where the contract mandates, terms and conditions of the contract mandates you to disclose each and every information. At that time, if you are silent, example, sir, best example is contract of insurance. Health insurance, let us say. Health insurance, when you sign health insurance, it asks questions. Are you alcoholic? Are you a smoker? Do you have any medical disabilities? Do you have any health problems? You say no, because you want premium less, you want to pay less premium. You will say no. You will say whether company will come and check us. No, then what is the problem? Tomorrow, later on, you suffer from lung cancer and you go to the hospital and you join there. Doctor gives a report that due to your smoking habit, you have got your lung cancer. Now insurance company will check. Insurance company will check when did you have this smoking habit. If insurance company knows that even before entering into a contract you had a smoking habit and you said no, I don't have a smoking habit, insurance company will deny your claim. It would not amount to breach of contract, because your utmost faith was required. You are required to disclose full things. In that case, your silence will be equal to fraud. Next one, company prospectus. Company prospectus is normally issued for share subscription, people to invest the money in the company. Now company is doing some fraud, or company has very big huge case going on against it. Company will not disclose it in its prospectus, but raises the money from the public. Now it will be responsible of the company. People who have given the money can claim back the money immediately. People who have given the money can claim back the money immediately. So it is left to the company, it is left to the people who have entered into a contract in this case. So here your utmost good faith is important. Or also please don't mute yourself, okay? I see many of you muting yourself. There will be disturbance. Please don't mute yourself. Okay. So, or where you are in a fiduciary relationship, there is something more called as fiduciary relationship. Sir, what is this fiduciary relationship? Relationship of trust. Let us say you have a son. You have a son who has attained the age of majority now. You have a son or daughter who has attained the age of majority. They don't know anything about horse trade. You are an expert in the horse trade. You want to sell a horse to your son or daughter. Your son will come and ask, or your son, you want to sell a horse which is ill or which is sick. Now it becomes your duty to disclose them, because they are new to the field. They trust you and they are entering into a contract. They are trusting you and enter into a contract. In these cases, your silence will amount to fraud. In these cases, your silence will be amounting to fraud. Or if a person comes to buy a car from you and he says that if you are silent, I am assuming that the car will give 25 kilometers mileage. If you are silent, I'm assuming that the car will give 25 kilometers mileage. Here, your speech is very important. Otherwise, your silence will be deemed as a fraud if the car doesn't give 25 kilometers mileage. Is it clear for you? So, these are the cases where if the contracts are entered under these circumstances, it will be called as contracts which are not entered in free consent, and it is voidable at the discretion of innocent party who has given the consent under these circumstances. It is at the discretion of innocent party either to execute the contract or to cancel the contract based on the way in which the consent was obtained. So with this, I can complete the portion of free consent. Next, we will be seeing little petty things which are important with respect to Contract Act. One is legality of objects. What is legality of objects? We need to understand. The consideration or the object of the contract, the motive of the contract should be lawful. When it will be considered as not lawful? When it will be considered as not lawful? Let us understand. The consideration or the object of an agreement is lawful unless. So that means all the contracts will have lawful objects. All the contracts will have lawful motive behind them to enter into a contract. But if it is forbidden by law, If it is specifically forbidden by law, enter into such type of contracts is specifically forbidden by law. Example, entering into a contract with minor, entering into a contract for dealing with smuggled goods, entering into a contract to kill someone, entering into a contract to kidnap someone. Here law is specifically saying that these are forbidden activities, these are criminal activities. These type of contracts are unlawful contracts or illegal contracts. These type of contracts are illegal, so they will not want to contract at all, first of all, because they are not enforceable by law, they are expressly prohibited by law. So legality of objects, I'm speaking about the consideration or the objects of the contract. The first one is forbidden by law. It should not be forbidden by law to call it as lawful. To call it as lawful, to call an agreement as lawful, it should not be forbidden by law. Second one, of such nature, if permitted, would defeat the very purpose of the law. Of such nature, if permitted, would defeat the very purpose of the law. So, for example, sir, let us say A has arrears of land revenue which is payable to the government. A has arrears of land revenue which is to be paid to the government. Now the rules of the government says, if at all someone has not paid the land revenue for a long period of time, their land will be put into auction. Their land will be put into auction and money will be recovered, balance will be paid back to them, if at all any. That means the land will be sold by the government, land will be put into auction by the government, and government will be recovering whatever due is there from this person. But the condition is that this person cannot purchase the land. Of course, he doesn't have any money to pay the land revenue. Why will he purchase? That is the logic behind it. So government says this person, the owner of the property, cannot, the person who has defaulted cannot buy the land in the auction sale. So now A enters into a contract with B. A enters into a contract with B and says that, see B, you go to the auction and you purchase the land. You go to the auction and you purchase the land. Later on, I will be buying it at same price. I will be buying it at same price. Whatever price you are going to pay. If you are going to pay 10 lakh rupees for the land, I will be paying you 10 lakh rupees and I will be purchasing the land. The contract between A and B is to sell or purchase the land which is sold in the auction sale. Indirectly, A is participating in the auction. This will defeat, if it is allowed, this will defeat the very purpose of this law. For that purpose, this is not a lawful consideration. This is not a lawful object of the contract. Or someone entering into a contract wherein person says, you will not recover the money from me. That means enter into a contract with person which violates the conditions of Limitation Act. Limitation Act says after 3 years, some person cannot recover the money from the person whom he has lent it. After due date, till 3 years, he has time. After 3 years, he cannot recover the money. Now, you are entering into a contract with the lender saying that he will not recover the money till 3 years. So automatically it will violate the condition. It will lapse the Limitation Act. So never it will be repaid. Never it will be repaid. Such a contract is not valid because it will defeat the very purpose of the law. It will defeat the very purpose of the law. Fraudulent transactions which are fraudulent. If you are entering into a contract for fraudulent object to do some frauds, to do some fraud business, then it will be called as then it will not be a lawful agreement. Then it will not be a lawful agreement. Involves or implies injury to the person or property of another. So you are entering into a contract with one person. So Mr. A has taken money from Mr. B. Let us say 50,000 rupees. In consideration, A is offering to work till his lifetime under B for no pay. Till his lifetime, he is agreeing to pay under B for no pay. Just for the purpose of 50,000, he is offering himself till his lifetime. So here what is happening? Person's personal property is getting injured. His life is getting injured under this condition. So this contract cannot be allowed. This will not be a lawful agreement. This will not be a lawful agreement. Next one. Court considered it as immoral or opposed to public policy. Entering into a contract with alien enemy, entering into a contract with insolvent person, court is considering them as immoral. Court is considering them as against public policy. In these cases, the contract is not to said not is said is not is does not have, sorry, contract does not have any lawful objects. In these circumstances, the contract doesn't have any lawful objects. Is that clear for you? Legality of object, is it clear to you? Yes, legality of object, is it clear to you? Shall I proceed? Yes, we'll proceed now. Give me 1 second. Okay, the next one is illegal agreements. Next one, we need to see a very small topic, that is illegal agreements. We need to see illegal agreements. What are illegal agreements? Agreements which are void ab initio. Agreements which are void at the very beginning. Illegal agreements are those which are void at the very beginning. That means at the time of entering into contract itself, they are void. They are not valid because they are expressly prohibited by law. They are expressly prohibited by law, punishable by the criminal law or any specific law. Punishable by any criminal law or specific law. So, entering into a contract to kill someone, entering into a contract of burglary, entering into a contract of sale of smuggled goods, all these things are illegal agreements. Sir, what will happen in case of illegal agreements? See, consequences of illegal agreements. No action can be brought in by a party. So, how this works? Let us say Mr. A enters into a contract with B, wherein B has promised to kill his wife, kill Mr. A's wife, Mrs. A. And A has given an advance money of 10 lakh rupees for this. A has given an advance money of 10 lakh rupees for this. Now, tomorrow, if B fails to do the terms of the contract, if B fails to do this, Mr. A cannot go to the court of law for claiming this money. Mr. A cannot go to the court of law to claim this money. Second example, Mr. A gives loan to Mr. B to buy a gun to kill Mr. C. Why Mr. A is giving the loan? Mr. A is giving loan to B to buy a gun to kill Mr. C. That means A is knowing this intention. A knows this intention which is illegal. A knows this intention which is illegal. So in this case, what will happen? In this case, what will happen? Obviously, the contract is illegal. Mr. A cannot go to the court of law if loan is not repaid. Even if the loan is not repaid, even Mr. A is not a participant here. Illegal agreement is Mr. B killing C. So this has nothing to do with this contract. Even then, Mr. A cannot go to the court of law. So I'll give you the difference between void agreements and illegal agreements. You need to understand the difference between void agreements and illegal agreements. All void agreements are not illegal, but all illegal agreements are void. How is it different? We need to understand. Simple. Say Mr. A has lent money to Mr. B. A has lent money to Mr. B, who has asked the money with Mr. A to give it to Mr. C as loan. Here Mr. C is a minor. Mr. C is a minor. So B is entering into a contract with minor for loan agreement. B is entering into a loan agreement with Mr. C. My question is, tomorrow if Mr. C fails to repay to Mr. B, can Mr. B file a case? Of law. I'm asking a question. Can Mr. B file a case in the court of law? No, you are saying no. Why? Because C is a minor. Agreement with the minor is void ab initio. Obviously, court will not recognize this contract. Court will not recognize this contract. Court will cancel the contract. Okay. Now, C did not pay to B. B did not pay to A. Can A file a case in the court of law? Can A file a court case in the court of law? Obviously, yes. Obviously, yes. Even if A, so two scenarios I'll take. Two scenarios I'll take. B, A is aware of B's contract with C. A is not aware of B's contract with C. Scenario 1, scenario 2, scenario 1, scenario 2. In scenario 1, can A file a case against B? Where A is aware that B has given money to C on loan. Who is C is a minor, being C is a minor. A knows that B has entered into a contract. B has asked the money for entering into a contract with C. C is a minor. See, observe, in this case, A can file. Nothing will stop A from filing the case because this is just a void contract, not illegal contract. This is the difference between void contract and legal contract. Void contract, even if this party knows that B is going to enter into a void contract, it will not stop him from exercising his rights. It will not stop from filing a case in the court of law for recovery of money from B. Even in this case, even if A is aware or even if A is not aware, that doesn't make a difference. I'll take another example in same lines. Mr. A lends the money to C, lends the money to Mr. B, wherein B uses it to give supari to Mr. D to kill someone. B is giving supari to kill someone. A has lent money to B to be used in this purpose, Now, two scenarios. A is aware, A is not aware. A is aware about the contract between B and Mr. D. A is not aware about the contract between B and Mr. D. Now, if A is aware, can A file a case in the court of law to recover the money if B fails to pay? Can A file a case if B fails to pay? No, very good. Because this is illegal. If A is aware about this A cannot file a case in the court of law because this is illegal. So in this case, this won't work. But in this case, coming to the minor's case, obviously A can file a case. What about if A is not aware? If A is not aware, anyhow, he can file a case. That will not make a difference because he is not aware of, but it rests on A to prove in the court of law that he was not aware of the fact. The burden of proof lies with Mr. A to prove in the court of law that he was not aware about this activity. He was not aware about this illegal activity. So this is about illegal agreements. These are about illegal agreements. Next one is agreements opposed to public policy. See, agreements opposed to public policy are not exclusive list. These are not exhaustive list. These are based on different case laws decided by the court. So public policy as such cannot be restricted to only this one. Public policy is nothing but the rights which are given to you. If a contract which you are entering is against the right which is given to you, that is called as agreements opposed to public policy, which are void. Even in this case, this is void. Agreements which are against to public policy are void. So, example, agreement in restraint of parental rights. You are entering into a contract with someone else which banishes you from your parental rights. You are transferring your parental rights. So Mr. A makes a contract with Mr. B, says, I will never ask back my children. I will transfer my children to you. So here A is giving up his parental rights. Agreement in restraint of parental rights. These type of contracts are not valid. This our court of law will not recognize them. These are void contracts. These are void contracts. Agreement in restraint of marriage. A entering into a contract with B saying that I will never marry in my life if you pay me 10,000 rupees. A entering into a contract with Mr. C saying that I will marry only you. I will marry only C. I will marry only D. This type of contracts are not valid. Next one. Marriage brokerage. A person promises to get a girl for you. So Hitesh's parent have hired a broker who has promised to get a girl for Hitesh. Now, after getting, sir, please don't mute yourself, sir, please. After getting the girl, Hitesh's parent denied to pay the commission to him. Can he file a case? He cannot file a case because marriage brokerage are against public policy. It is held that these are against the public policy. Agreement in restraint of personal freedom. So you are entering into a contract with someone. You are entering. So I said you example to work under. So you have taken a money from Mr. B. You have taken money from Mr. B, and you are entering into a contract in return to him, saying that I will not leave my job, I will not leave my current house, I will not leave my anything. So that means just because of one contract, you cannot enjoy anything in your life. You cannot enjoy the personal freedom. Even that will amount to agreements which are opposed to public policy. Even that will amount to agreement which are opposed to public policy. Last one is agreement in restraint of trade. If a contract is stopping you from doing the trade activities, because you know in fundamental rights you have, when you read fundamental rights, you said you have right to practice any profession or any trade or any business. So if a contract is stopping you from doing it, such contracts are void contracts. Next is void agreement. Agreement which are not enforceable by law are called as void agreements. Since there is no enforceability under the law, they are void ab initio and cannot be called as contracts. I am speaking about void agreements. I repeat, I am speaking about void agreements. Void contracts are different. Void contracts are not void ab initio. Void ab initio means void at the very beginning, unenforceable at the very beginning. Those are called as void agreements. These are all void agreements. Plus, these are also void agreements. Plus, entering into a contract with these people are also void agreements. Entering into a contract with these people are also void agreements. That means those agreements which cannot be enforced in the court of law are called as void agreements. Void agreements. I'm using the word agreement. Now you know better, because contract is nothing but enforceability by law. Only then it will be called as contract. So void agreements are different. Void contracts are different. Void agreements are different. Void contracts are different. So void contracts are valid at the beginning. Later on they turn to void. This one. Later on they become void contracts. So if I take voidable contracts, voidable contracts are valid at the very beginning. They are valid contracts at the very beginning. But if it is cancelled, by the innocent party, then it becomes void contracts. Are you able to understand what I'm telling? Yes. Are you able to understand the thing which I am trying to convey? Yes. Are you understanding it? Do you have any doubts there? Do you have any doubts? No doubts. Clear. Okay, super. Next one is wager. So you can see here, now it's time of IPL. It is high time of IPL. So which party will win? Which party will win? You are going to bet on that party. You are going to bet one party. So an agreement between two persons under which money or money's worth is to be payable by one party to another party. So one party has to pay money to another party. But when it will be decided, when to pay? On happening or not happening of a future uncertain event. So A says to B, if it rains today, I will pay you 1,000 rupees. If it rains today, I will pay you 1,000 rupees. So what is the contract between them? And B says, if it doesn't rain, I'll pay you 1,000 rupees. There's a contract between them. If it doesn't, you pay me 1,000 rupees can also be the contract. So here, what is it? It is a wager. It is a bet. Agreement between two party to pay the money or money's worth. It is not essential that only money should be paid, money's worth should be paid. Okay. On happening or not happening on future uncertain event. Match. Today CSK will win. Today RCB will win. RCB will always win. Isala kapu namde. Correct? Yes. So if you are entering into a contract if you are entering into an agreement in this type, it is called as wagering agreements. It is called as wagering agreements. Did you understand this? Wager and contingent contracts are different. Now we have to understand one thing before going into contingent contract. We have to understand wagering agreements, whether they are legal or illegal. So I can't say the word legal. Instead of legal, I'll use the word void or illegal. You know the difference between void contracts, void agreements and illegal agreements. Void agreements, parties, third parties or parties who are not directly part of the contract can enforce the contract. They can file a case at least. But in case of illegal, nobody can file a case. In case of illegal, nobody can file a case. So A lends the money. So A and B are into a wagering agreement. A and B are into a wagering agreement, wherein A promises to pay B if CSK wins. A promises to pay B if CSK wins. If CSK loses, B has to pay to A. Now, fortunately, CSK loses and B has to pay to A now. B has to pay to A. B has to, sorry, I made a blunder here. Okay, let us keep like this. A, B, two persons are there. Match is of RCB. Match is of RCB. Now A is dead sure that RCB will never win. RCB will never win. That is what A believes. So A enters into a contract with B, says, if RCB wins, if at all RCB wins, I will give you 1 lakh rupees. If RCB wins, I'll give you 1 lakh rupees. If it doesn't, you have to pay me 1 lakh rupees. If it doesn't, you have to pay me 1 lakh rupees. Let us see the contract first. Agreement between two persons. Two persons are there, A and B. Which money or money's worth is to be paid? 1 lakh rupees. Money's worth is to be paid. Money is to be paid. Whether it is payable directly, no. On happening or not happening of uncertain future event, we don't know whether RCB is going to win or not. It is uncertain to us. It is uncertain. On happening, if RCB wins, B has to. If RCB wins, A has to pay to B. If RCB loses, B has to pay to A. This is a wagering agreement. Okay. Fortunately, RCB wins in that match. RCB wins in that match. Now A has to pay to B. A doesn't have money. A was bluffing. A doesn't have money. So C lends the money to A. C is aware about this contract. So C lends money to A to give it to B. Or C gives the money on behalf of A to B. C gives the money on behalf of A to B. Now tomorrow if A doesn't fail to C, if A doesn't pay to C, C cannot file a case in the court of law. When it is illegal, if it is illegal, if wager is illegal, this is the case. If wager is void, then obviously C can claim, C can file a case against A and C can claim. So in Maharashtra, it is illegal. In rest of India, it is void. So that is what I have written here. In case of Maharashtra, it is illegal. In case of rest of India, it is just void contract. It is just a void contract. That means parties who are not directly related in the contract can file a case. Contingent contracts. Contract to do or not to do something if some event collateral to such contract does or does not happen. See here, wager is nothing but it is totally dependent on uncertain future event. The contract itself is dependent on uncertain future event. But here it is not that way. The contract is to pay something or the contract is to do something. But the doing of the contract is dependent on something, some other event. Doing of something is dependent. For example, A says to B, I will sell you all the products that I receive if Z sells the products to me. If Z sells the products to me, I will sell it. Whatever Z is selling to me, I'll give it to you. Or if I receive the iPhone to my shop, I'm a mobile dealer. I'll say, if I receive iPhone today, I'll be giving it to you. This is a contingent contract. So contract between me and my customer is that if iPhone comes to my shop, I'll be giving it to him. This is not a bet here. This is not a bet here. Contract is to sell iPhone. But the happening of the contract is dependent on third event. Such type of contracts are called as contingent contracts. Insurance is the best example for contingent event happens. Is it clear? Contingent contract. Are you clear with this? Shall I proceed? A very small part, last part is remaining. Let us cover it. Yes. So discharge of contract or termination of contract. How will a contract come to end? Very simple. Very simple, sir. If you are entering into a contract, perform it. Simple, done. That's it. Correct. Performance of contract. Very simple. If you are entering into a contract, perform it. Done. Contract is closed. When both the parties perform their obligation, the contract is closed. The contract comes to an end. The contract is discharged. The contract is terminated. So A promises to sell the car to B. B promises to give him 5 lakh rupees. When A delivers the car, she gives the money. Contract is over. But it is not that simple, sir. Only some of the people can perform the contracts. There are other people who don't perform the contract. So mutual consent or agreement. Later on, they come to an agreement that let us cancel this contract. Let us cancel this contract. So A promises to sell the car to B. B promises to buy the car from A. But suddenly COVID happens, lockdown comes, and there is no money with B to buy the car. Now B calls to A and says, see, Mr. B, this is the condition. They are friends, good friends. They are mutually agreeing to cancel the contract. Or they may extend the time. They may novate the contract. They may renovate the contract. They may change the terms of the contract. This is called as mutual consent. Changing the terms of the contract or cancelling the contract with the understanding between the parties is called as termination of contract with mutual consent. Lapse of time. If contract is for 3 months, if you are into an employment contract with your employer for 3 months, Pratiksha, please shut down. Yes. If you are into contract with your employer for 3 months, please mute yourself. Don't unmute yourself. Pratiksha. Okay. Pratiksha, please mute yourself. Okay. Okay. So I was speaking about performance of contract. Mutual agreement, you understood. Lapse of time. So you are into an agreement with your employer. You are into agreement, employment agreement between you and your employer for three months. You have entered into a contract for 3 years. Let us say 3 years. At the end of 3 years, you are free. Your contract is performed. You are free. The contract is over. Next one, operation of law. Sir, there is a contract between me and a Chinese partner. We are into a contract to supply of goods. Suddenly, there is a war broken between us. Suddenly, there is a war between India and China. Law says you cannot enter into a contract with your enemy. So obviously, the contract becomes ceased. The contract becomes ceased. So Mr. A and Mr. B enter into a contract for sale of plastics. After the entering into a contract, later on, what happens? Government makes a rules that selling of plastic is illegal. Automatically, the contract is terminated. The contract is terminated. Impossibility of performance, frustration. See, these are all related here. Frustration, impossibility of performance means while the entering of contract, you are so confident that contract could be performed, but later on circumstances comes up in such a manner that contract cannot be performed. This is impossibility of performance, impossibility of performance, frustration. For example, sir, A enters into a contract with B wherein A promises to write and give his autobiography and B promises to publish it in return for some consideration. After A's meeting, A comes out of the office and A meets with the accident immediately. Now, the party to the contract itself is not there. There is a frustration. Contract cannot be completed. Contract comes to an end. Contract comes to an end. And the last part is breach of contract. What is breach of contract? When promiser neither performs nor does tender the performance. You have called Arijit Singh to perform at a particular location. You have entered into a contract with Arijit Singh. Now Arijit Singh doesn't turn up, or Arijit Singh did not even call you and tell that, see, instead of Arijit Singh, Surjit Singh will come. I have tendered my job to someone else with your consent. If this doesn't happen, then it is called as breach of contract. Even if the party doesn't even try to perform the contract, it is called as breach of contract. There is a breach of contract. So breach of contract can be of two types: anticipatory breach, actual breach. Anticipatory breach means even before the completion of term of the contract or the date of contract, the party, the promisor, does an activity which gives an implication that the contract will not be performed. For example, I'll give an example. Mr. A enters into a contract with Mr. B for sale of his car. Let us say the contract was fixed for 25/10/2020. But on 20th 10/2020, Mr. A sells this car to C. This is called as anticipatory breach. That means the promisor is making a condition in such a way that, building the condition in such a way that the performance itself is not possible. The performance becomes impossible. This is called as anticipatory breach. That means now you can anticipate, you can predict this contract will not happen. Actual breach means what? On 25th A not delivering the car is called as an actual breach. On 25th A not delivering the car is called as actual breach. Whereas if he is doing some activity, or on 20th he sends a letter to Mr. B saying that I don't want to sell my car. Even this is anticipatory breach. Are you getting it? Yes, come on, please reply me quickly. Are you getting this points, whatever I'm telling? Yes, are you 100% sure? Anticipatory breach and actual breach. Very good. So this is called as breach of contract. So what are the remedies available? So once you know that there is a breach of contract, all you can do is you can go and file a case. You can file a case for claiming the damages. You can file the case for actual performance of the contract, or you can file for quantum merit, or you can do anything for that, or you can stop your part of the contract. You can stop paying him because you are also having obligation to pay. You can stop the contract. You can cancel the contract. All in all. Now question will come as to why all of you are muting again and again today. I'm not getting it. Many people are unmuting yourself. It is a problem here. Since the class is going live, please don't do that. Okay. So breach of contract is over. I'm speaking about the remedy. What are the remedies? So wherever there is right, there is a remedy. So contract is your right to receive the part of the contract, right to get the performance of the contract is your right. Now if the right is not performed, you will get a remedy. What is the remedy? Go and file a case. Now question will come as to anticipatory breach. When to file a case in case of anticipatory breach? Immediately, or you have to wait till the completion of the time of the contract. So here question comes as to whether B has to wait till 25th or B can file a case on 20th itself. It depends on B. Whenever he feels like, either he can wait till 25, he may think that A may give some other car or some other compensation, or on 20th itself he can go to the court of law and file a case. Now what will happen? I'll tell you what is the implication of this anticipatory breach and filing a case immediately or filing a case later. I'll tell you what happens. Mr. Z has entered into a contract with Mr. K. Mr. K is in UK and Mr. Z is in India. Contract is between Mr. Z and Mr. K. Mr. Z, or let us say Mr. K is in Pakistan. Let us say Mr. K is in Pakistan. So Mr. Z has entered into a contract where Mr. K will be supplying goods to Mr. K will be supplying goods to Mr. Z, and in return Mr. Z will be paying the amount. So the promise was that the contract will happen on 20th December 2020. Now on 20th October 2020, Mr. K says, I will not sell you. There is a breach of contract. K has denied performance of the contract. There is a breach of contract. This contract is breached. Now what can Z do? Obviously Z can file a case. Question as to filing the case is when to file the case, whether he has to wait till 2012 or he can file the case immediately. He has the option. He can either file the case on 2012 or he can file the case immediately on 2010. Let us say he decided to wait till 2012. He decided to wait till 2012, seeking that K may perform. Tomorrow K may change his mind and K may perform. Now what happens on 2020, there is a war between India and Pakistan, which will make literally Pakistan alien enemy. Contract with alien enemy is illegal, or contract with alien enemy is against the public policy. Contract with alien enemy is void, not illegal. It is void. Now, if Z goes to the court of law on 2012-2020, Z cannot call for compensation in this contract. Z cannot call because Z assumed that the contract is not yet breached. Z is waiting till the date to get over. Now Z will not be compensated in this case. Z will not be compensated in this case. I will give you another example. Mr. Gopal was appointed as an employee in XYZ Limited. In XYZ Limited, Mr. Gopal was appointed as an employee and his term of employment was about to start on 1/11/2020. On 1/11/2020, this happened. His appointment happened on 1/10/2020, but his term of contract started. His contract was start on 1/11/2020. On 2010/2020, he receives a call saying that we will not appoint you as an employee. We are going to cancel the contract. Again, this is a breach of contract because they already entered into an agreement wherein the promise was to appoint him as an employee on 1/11/2020. Now, if 2010-2020, when he comes to know, if he files a case, the case will be valid and he will get the compensation for this. He will get the compensation for this because this will be considered as anticipatory breach. This will be considered as anticipatory breach. With this, we have covered all the major aspects of contract. There are three small areas, that is with respect to your contract of agency, indemnity, and contract of guarantee. I'll just briefly tell you what is contract of indemnity. Contract of indemnity means, I already said you, insurance contract. So what is it? One party promises to pay another party in case of any loss occurring to third party. In case not third party, that party. So an insurance company making a promise to pay Mr. Z in case of any theft in his building is called as contract of indemnity. What is contract of guarantee? Surety, we say, while taking the loan. One party assures another party that if at all the money which is lent to the person. So I'll give the example he like this: A, B, C. So B lends the money to A with the surety of Mr. C, or with a guarantee of Mr. C. Now, contract between C and B is called as contract of guarantee. What is the guarantee? Guarantee that C gives to B is that if at all A fails to pay, I will be paying the money. This is called as contract of guarantee. This is called as contract of guarantee. Then comes contract of agency. B appoints a person, Mr. A, as to act as his agent. Now A will be representing Mr. B for all the purpose. This right where A is getting the right to represent Mr. B is called as contract of agency. This is called as contract of agency. So these are the brief areas which are there as special contracts in your textbook. So with this, we have already covered major aspects of Contract Act. Without wasting time, I'll be proceeding for law of this one. I'll be proceeding for law of torts. So a very simple law. Let us focus on law of torts now. So So please give me 2 minutes. So what is tort? We need to understand. Tort is nothing but civil wrong. Tort is called as a civil wrong. Sir, wrongs can happen. Wrongs means doing something bad. Doing something that is not favorable is called as wrong. Wrongs can happen in two ways. One is criminal wrong, one is civil wrong. If you are speaking about criminal wrong, it has criminal loss. So criminal wrongs will normally be disturbing the public at large. It is not a one-to-one relationship. So if you are committing a murder, it is not just the person who has got murdered is getting affected. It is the entire society that is going to get murdered, that is going to get affected. For that purpose, you'll be punished under the criminal laws. You'll be punished under the criminal laws. You'll be punished under the criminal laws based on the acts which are applicable. So this is what criminal law is all about. Coming to your civil laws. Civil laws has two things. One is breach of contract, which we already studied now. Breach of contract. Even breach of contract is a wrong because you are not following the terms and conditions of a contract. That is called as breach of contract, which is wrong. Those which are not breach of contracts, but still a wrong, but still a civil wrong, are called as torts. Are called as torts. You can see the chart here. Wrongs are of two types: criminal wrong and civil wrong. Breach of contract and breach of trust is called as one category. The other one is torts. So see, criminal wrongs will be dealt in criminal acts. Whatever the criminal laws are there, those will address this criminal wrongs. Those will address this criminal wrongs. How, breach of contract and all those things will be addressed by Contract Act. Maybe Contract Act, maybe your Sale of Goods Act, or maybe Partnership Act. Everywhere you are going to deal with these things. Deepti, please mute yourself. Yes. The last one is torts. So in specific, there is nothing called law of torts. There is nothing called law of torts. There is no specific act for torts. But court has the right to decide the liability in case of tort. Sir, example if I have to give. If you are committing a murder, that is different. It is a criminal act. If you are committing a breach of contract, it is there in the contract act itself what is to be done. But if you are assaulting a person, if you are going and shouting at a person, if you are threatening to kill someone, if you are abusing someone, if you are defaming someone, if you are charging someone, if you are going to hit someone, if you are going to slap someone in public, if you are not allowing a person to enjoy his freedoms, if you are not allowing a person to go into his property, if you are blocking his property, all these things will be amounting to torts. These are not specifically defined anywhere, but these are understood due to various situations. So you may see a lot of torts in the newspapers, regular daily newspapers. You will see a lot of torts. This person shouted with bad words. He used bad slangs. He defamed that person. He charged with defamation cases. He claims 1 crore rupees as defamation. So all these things are torts, and these are to be recognized by the court of law. Court of law has to recognize them. Court will see the consequences out of it, and court will decide the damages. Court will decide the damages. Such type of things are called as unliquidated damages. I'll come back to you that. Before that, let us understand the definition of tort. Let us understand the definition of tort. As per section 2 subsection M of the Limitation Act, you saw the Limitation Act yesterday also in the contract, where no consideration we said in case of Limitation Act. So what does Limitation Act says? As such, there is no definition for tort, but if you go and search in Limitation Act, you get a definition which says tort means a civil wrong which is not exclusively a breach of contract or breach of trust. That is what we understood now. The person who is doing a tort, the person who is abusing another person, the person who is denying the right for another person is called as tortfeasor. You can see here. This person, this girl, this lady is bullying this girl, actually bullying this girl. She is pulling her hair. This is against her freedom. This is against her freedom. So the person This person is called as tortfeasor. This person is called as tortfeasor. See, here also you can see this person is threatening to hit him. This person is threatening to hit him. He is very strong. He is physically very weak. The person who is threatening to hit him, this person is called as tortfeasor. This is a tort here. This is a tort here which is going on. As we proceed, you will understand clearly what is tort. Right? Here, this child is getting abused. This person is shouting at his child, abusing this child. Even here, this person is called as tortfeasor. This person is called as tortfeasor. So when will you call it as a tort? We need to understand. When will you call an activity as tort? Presence of an act or omission by a tortfeasor without justifiable reasons, with which he is causing a harm to the plaintiff. So plaintiff means the person who is going to file a case. Complaint. The person who is going to file a complaint is called as plaintiff. So defendant, that is who is going to defend. If that person is going to commit any act, or if that person is going to do any omission, the effect of which will be causing harm. See, harm need not be physical. Harm can be mental also. All in all, when I say harm means harm to your legal rights. Harm means harm to your legal rights. Someone is denying you your rights. Someone is not allowing you to practice your right. So both ways. If someone is denying you or someone is not allowing you right practice, someone is not allowing you to practice the right, or someone is saying no, you can't do that. Both the ways this can be interpreted. This is called as tort. So first, there should be a wrongful act, an act which causes violation of someone's legal rights without legal excuses, irrespective of loss caused. Sir, for example, someone is denying you your right to speech. Someone is abusing your caste. Someone is abusing your right to vote. Someone is not allowing you to reside in your home, or someone is encroaching in your home. Some outsider has come inside your home. He is not going out. All these are torts. Someone is coming to you and shouting at you like anything. Nuisance. Someone is shouting at you like anything. Someone publishes an article which is defaming you. We are not speaking about the consequences, sir, but we are speaking about your legal rights. How much did it impact? That is not relevant to us. But did it cause a problem to your legal right? That is important. So there should be a wrongful act. It is not illusionary thing that is happening. You cannot assume this person, if he does this thing, Hagal. There should be a specific act which has happened, and such an act should have caused what? Such an act should have caused damage to your legal right. Legal damage, the next point. The result of such act should cause a legal damage, injury, or invasion to your legal right. So to understand what is this legal damage, we need to understand two maxims. One is injuria sine damnum, the other one is damnum sine injuria. So before that, let us understand this legal remedy. So what is happening here? There should be a wrongful act. There should be an act which is very wrong, which is causing any damage to your legal right. So there should be an act, maybe abusing, maybe cursing, maybe battery, or maybe trespassing, or maybe defaming. All these are activities. This one we will be learning in detail later, all the things. But let us understand, there should be a wrongful act. That means it should cause a wrong. It should cause a damage to you. And that damage should be a legal damage. When this happens, there should be a legal remedy. Whenever there is a right, your legal right is getting abused. Your legal right is getting abused. So you should have a legal remedy. Legal remedy means what? The lawful act must come under the law. The lawful act must come under the law. That means you should file. You should be in a position to file a case in the court of law. You should be in a position to file a case in the court of law. Then court will recognize, and the first remedy here normally is unliquidated damages. You are going to get the damages which you faced. See, we are not speaking about any monetary damage or physical damage. We are speaking about unliquidated damages, which court will decide. How much can be the damages? In this case, court has to decide. It may be damage to your reputation. It may be violation of your fundamental rights. So this is what we are speaking about tort. Are you able to understand this? Is it clear? Shall I proceed? Shall I proceed to the next part? I need to discuss three maxims here. I need to discuss three very important maxims. One is damnum sine injuria, damage without injury. Sir, what is damage without injury? Damage without injury means actually there is a loss to you. Actually, there is a physical damage to you. Either you are losing money, or you are losing your reputation, or you are losing your rights. But there is no injury. Injury means legal consequence, violation of your legal rights. So when there is a damage made to a person without causing any injury to his personal rights, no legal remedy can be claimed for. So this will not amount to tort. This is not tort. Damnum sine injuria is not tort. To call it as a tort, there should be effect on your legal rights. We are speaking about legal rights. Someone may come and cause you a lot of physical damages, but if it is not defeating your legal right, then it cannot be called as a tort. For example, so let us say there was a school, GGS school, the GG school, that is your Gloucester Grammar School. This was Gloucester Grammar School, where Mr. A was a lecturer. Mr. A was very popular. That student used to come to his college just to hear to his lecture. Because of him, the demand of the college had increased like anything. Now, one fine day, Mr. A had some conflict with this school. So what did he do? He resigned and opened a new school adjacent to the campus. Adjacent to this campus, he opened a new school, due to which there was a huge loss of revenue to this person. There was a huge loss of revenue to the GG school. So what did GG school do? Gloucester Grammar School, what did they do? They went to the court of law and filed a case against Mr. A, saying that he has caused a damage to us. So this is a tort. He has caused a damage to us. So we need compensation, is what GG school said. Court observed the case. Court asked one question. Did he stop you from running the school? No. Did he do something that students can never enter your school? Did he put a fencing there so that students will never enter the school? Let us say the approach road is like this. Did he block this road? No. Did he do something? Did he defame your school, saying that your school is so bad? Did he do that? No. What did he do? He just opened a school, which is his right. He can open, any person can do any profession. That is what he did. Your right is not infringed here. Yeah, we agree. There is a damage. Due to this school, your revenue is getting lost. But it is not affecting your legal rights anywhere. And so, this will not be called a tort, is what the court said. So this is damnum sine injuria. Damage is done. Monetary damage is done to the school, but there is no legal damage. Their rights are not denied. He did not block. He did not do defamation. He did not cause anything that will stop the school from doing the business. Are you getting a clarity on this? Did you understand this? This is nothing but Gloucester Grammar School, which is applicable for damnum sine injuria. Damnum sine injuria is not a tort. Remember this. Damnum sine injuria is not a tort. Damnum sine injuria means what? Damnum sine injuria means causing damage without legal damage, causing physical damage without legal damage. That is damnum. Damnum, damage without injury. Injury stands for legal rights. Injury stands for violation of legal rights. Next is opposite of this. Injuria sine damnum. No damage is caused. There is no loss of your money. There is no loss of your reputation. There is no loss of anything, but there is loss of your legal right. You have been denied of your legal right. In that case, it will amount to tort. So for tort, legal injury is very important, not the physical injury. Legal damage is very important. Violation of your right is very important. Violation of your right is very important when it comes to tort. So injuria sine damnum. What is injuria sine damnum? Injury without damage. Injury without any damage, where there is no damage resulted. Yet if there is infringement of legal right, remedy can be claimed under the law of torts. So Ashby versus White case. What happened in Ashby versus White case? So Ashby went to cast his vote. The officer who was there said, no, already lot of votes are casted and the candidate is almost about to win, so I'll not allow you to vote. That means he was denied of his right to vote. He was denied of his right to vote. Was there any damage? No. Was there any physical harm to him? No. Was there any abuse? No, there was nothing. But only that his right was not allowed to exercise. He was denied of his right. He was denied of his right. Now what happened? He went to the court of law. Court of law said, yes, there is a damage to his legal right. That means there is an injury here. So obviously, even if there is no damage, he is liable to receive the compensation. He is liable to receive the compensation. This is what injuria sine damnum means. Tell me yes if you are clear with this. Injuria sine damnum. Are you clear with this? So tell me, in which case there is tort? Damnum sine injuria or injuria sine damnum? Tort comes in case of injuria sine damnum or damnum sine injuria. Injuria sine damnum and not damnum sine injuria. So keep this point in mind. Keep this point in mind. Next is mens rea. What is mens rea? Actus no facit renim nisi mens sit rea. Act itself creates no guilty in the absence of guilty mind. So just because you go and hit someone as a defense, if you might go and hit someone as a defense. There was no intention to harm someone. There was no criminal intention to harm someone. So this is mens rea. Mens rea means guilty mind. Mens rea means guilty mind. So what does it say? It means when you are to do an act, mind must agree with your act. That means with the consent of your mind, if you are doing, out of mistake, if you did something, it will not amount to crime. It will not amount to crime. But if you are intending to do that, purposefully you are doing it. If you are going and hitting a person purposefully, if you are going and assaulting a person purposefully, if you are going and doing a murder purposefully, then it will amount to crime. Act must be done either with wrongful intention or negligence. If you are having a wrong intention, but even for tort purpose, there should be mens rea is what they are saying. For tort purpose, mens rea is essential. So what does it mean? For the purpose of tort, your mind should be thinking wrongfully. For wrong purpose only you should have done that. It is not that out of anger you did some things immediately. In that certain situation you acted upon. So someone was coming to attack on you and you felt that he is going to attack you and you acted on defense. That is not a tort. That is not a tort. So someone came to you with gun and you felt that he is going to hit you. He is going to hit you. Now you acted upon as a defense. This is not a tort. So you say a right to travel anywhere in India. You say you have a fundamental right to travel anywhere in India. So someone trespasses your land. Someone comes to your private land. You try to make him outside. You use some little force to drive him outside of your land, drive him out of your land. Now it is not a tort. Now it is not a mistake on your part, because your intention was not to harm anyone, but your intention was out of self-defense. Your intention was out of self-defense. For tort, mens rea, the guilty mind should be present, but this guilty mind is not applicable in case of absolute or strict liability. What is strict liability? We'll understand now, next part. But this mens rea concept is not applicable. Presence of guilty mind is not essential in case of absolute or strict liability. You will be liable even if you did not have any intention to do any harm to any person. Even if you did not have an intention to harm, still you will be liable to pay something in case of tort under absolute or strict liability. Under absolute or strict liability. So This is all about tort. Now we have to understand how tort is different from crime. What is the difference between tort and crime? So crime is a public thing, whereas tort is a very private thing. So how is it public thing? So you are going to murder a person and you call it as a crime. So how is it public? It is related to society at large. It will disturb the society at large. If you are causing a robbery, if you are causing a theft, if you are causing a murder, if you are causing a kidnap, this is going to affect the public at large. That is why specific laws are made for that purpose, and those are punishable under those laws. That is what crime is all about. But tort is not that way. Tort is single attack. Tort is an attack on single person. Tort is an attack on single organization. It is going to hit straight away on that person or that organization. It is very private thing. So there is no punishment which is pre-decided in case of tort. We call them as unliquidated damages. So what is the ultimate intention here? If you are committing a crime, the intention of the law will be to punish you. Intention of the law is to punish you so that it will not be repeated in entire society. If you are free without punishment, what will happen? People will start doing it. It will cause a nuisance in the public at large. It will cause a nuisance in the society. But tort is not that way. Tort is to compensate the person who is affected by it. So you have created a defamation. You have done defamation of one person. You have used these photos and you have done some unfavorable things and you have put it on internet. Now, two things have to happen. One, you should be punished only for the restriction, only for that area. Now, the person who has suffered, he should be compensated. For that purpose, actual intention is to recompensate for the loss suffered. So again, I said, you are doing a defamation. There is no loss for him. Physical, this monetary loss, there is nothing. But there will be lot of loss of reputation, which is again a legal, which is again a legal right to have a dignified life. So automatically it will amount to tort. But crime is not that way. It is a breach of public right. Objective is to punish. Objective is to punish. Coming to difference between tort and breach of contract. Coming to difference between tort and breach of contract. See, now we know contract is a fixed terms and conditions between people. So obviously, with respect to contract, if at all there is a breach, that means the terms and conditions which are fixed by the people are violated. That is what you call it as breach. That means if I promise to sell you the car and if I don't sell the car, that is breach. But tort is not that way. Tort is not predetermined. Tort is going to be decided by the law. Tort is going to be decided by the law. Contract is not that way. Breach of contract is not that way. Your breach of contract is determined with the terms and conditions of the contract itself. You have to show the contract. You have to tell in the court of law that this was the contract and he did not perform as per this. But tort is not that way. You have to go and tell in the court he has done this thing. Court will decide whether it is tort or not. Next one, unqualified damages. No predetermined damages. No predetermined. There is no predetermination in case of tort. Unliquefied damages. But in case of contract, it is not that way. In the contract itself, it is decided. In the contract itself, the damages are fixed. So that means if at all this person fails, what is the compensation to be received? Or it can be valued with the help of value of the contract. So this is about breach of contract versus tort. Breach of contract versus tort. Tell me one thing. I am assuming that you are getting a clarity on all the concepts, though we are in a hurry, though we are speeding up because this is a crash one, but I hope this is very much clear to you, whatever we are discussing now. Yes, everybody, I want each one out to confirm. Yes. Okay. Going ahead, we have to understand what is the strict or absolute liability. Strict or absolute liability means whether you have done the mistake or not. Whether you have committed the tort or not is not relevant to us. But if a tort has happened, you will be punished for it. Even if you are indirectly related to it, you will be punished for it. Maybe your employee has caused the damage. Maybe some contractor has caused the damage. Maybe due to use of land, some damage has been caused. Maybe due to various factors, the damage has been caused. But still you will be punished. So in these cases, the defendant will be held liable even though the harm to plaintiff occurred without the intention or negligence on the part of defendant. This is what I said, even if there is no mens rea. Even if there is no mens rea, liability will be there. Criminal mindset or intention to harm is not essential in case of strict or absolute liability. You have taken all your cares. Let us say you have a land adjacent to which there is another land where human beings dwell. Yours is a land where manufacturing happens. And out of nowhere, you have taken all the precautions, but there was an explosion in your land on one fine day. There was an explosion in the factory. There was an explosion in the factory, which caused damage to the people who are living in the side by location, in the side by vicinity. Now what happens? Even though you did not cause the harm, but since you are party there, you will be made to pay the liability. You will be made to pay the liability. This is what strict or absolute liability is all about. So where liability will arise? If for inevitable accidents. So your land consists of some dangerous materials, and even without your mistake, even after taking enough precautions, that dangerous material escapes from your land and causes damage to other persons. Then you will be held liable. Sir, I did not have any intention, correct? You are doing it for manufacturing purpose. You did not intend to kill someone. You did not intend to kill someone. It was not intentional. But still, since it was there in your land and it escaped from your land, automatically you will be made liable for this. If for inevitable mistakes, sir, we did some mistakes which caused damage to certain persons. We did not intend to damage them, but automatically it did happen. So while speaking, maybe in the general meeting, while speaking, I mentioned some names unintentionally, but due to which an innocent had to suffer, automatically you will be held liable. You will be held liable for it. Vicarious liability. Your employee is doing a mistake. Your servant or your agent is doing a mistake. Automatically you will be held liable for it, even though whether you knew it or not. These are called as strict or absolute liabilities. So what are we trying to tell in strict or absolute liabilities? We are trying to say that even if there is no intention, there was no negligence on your part, but still if that has happened and it has affected the plaintiff, then you will be held liable for it. You will be held liable for it. This is strict or absolute liability. So conditions for strict or absolute liability has been decided in Rayland versus Fletcher case. Rayland versus Fletcher case. So this picture can explain you what is Rayland versus this one, Rayland versus Fletcher case. So you can see there is land which is divided among two people. One is Rayland and one is Fletcher. So Rayland is one who is standing here and showing what did you do to my land, and this is the person who is innocently showing the water tank. That is why they did this picture. By this picture, I think so it is more clear for you. Let us see what happens. So Rayland and Fletcher were doing a business, and Rayland had some undertaking here. He was doing some business. Even Fletcher was doing this business, and he had mill here. He had his mill here. So now what happened? One fine day he wanted to put a water tank. So he endorsed this work for some engineers, outsiders, independent contractors. So these people did the work for him, did the job for him. And after everything, enough precautions were taken so that there will be no harm, and all. So after all the things, once water was filled to this tank, there was lot of wastage, and because of this some land issues, they did not make it proper, and the water escaped to this person's property, causing damage to him, causing damage to Rayland. Now Rayland went to the court of law and said, see, my honor, this is the thing, and his water escaped from his land and it came to me, because of which I had to face a lot of losses. Of course, Fletcher was saying that I did not do any mistake. It happened automatically. So I did not do any mistake. Now court observed, see, under this case, you will be considering it as a case of strict liability. court made two laws here, two rules here. What did the court say? There should be non-natural use of land for by the defendant. So court observed whether there was a non-natural use of land. Yes, there was non-natural use of land. How, sir? A water tank was established in the natural land. If it was well, it was fine. If it was a small tank for day-to-day purpose, fine. This was a huge tank. This was a huge tank. So automatically court said that there was non-natural use of this land. There was a non-natural use of this land, wherein first condition was satisfied. Second one is dangerous substance. Dangerous substance need not always mean those substances which are in the nature of danger. Dangerous substance means a foreign substance which will cause damage. Those are called as dangerous substance here. Dangerous substance, non-natural substance must have escaped to defendant's land. So here water escaped to this person's land. So automatically Fletcher was made liable under strict liability or absolute liability. Did you understand the case? Very important case, very important case. Fletcher, Rayland versus Fletcher when it comes to law of tort. Did you understand? So 3 case laws are very important. One is this one, your Gloucester Grammar School. The other one is Ashby versus White, and the last one is Rayland versus Fletcher. These are the 3 very important case laws. Are you all clear with this? Please give me a confirmation so that I can proceed for the next part. Yes. So next part is exceptions to the rule of strict liability. When and all, there will be no cause of strict liability. Damage due to natural use of land. Damage due to natural use of land. What does this mean now? Damage due to natural use of land. You have used the land naturally. You did not use the land. You did not introduce any foreign substance. You did not use the land such that it will cause any damage to other person. For example, so you established a well in your land. Well, there was a well in your land. So this is a piece of land, 2 wells, 2 lands are there, 2 lands are there. So you had a well in this land. This person had a borewell here. This person had a borewell here. Or let us make it more clear. Let us make the example more clear. A, B, 2 people are there. A had a well in his land. A had a well in his land, which had enormous water. Now, one fine day, B decided to open a borewell, which is natural. B decided to open a borewell, which is natural. Now, due to this B's borewell, the water force in A's well reduced. The water level in A's well reduced. Now question comes, can A file a case in the court of law asking for tort, seeing that B has done a tort and strict liability has to be exercised? If B's use is natural use, see, we can't decide exactly here if B's is a natural use. If in that area putting a borewell is natural one, it is very natural to put a bore in. So obviously in one land, one borewell and all can be there. So if it is natural use of this land, then obviously there is no strict liability. Court will say no liability. Court will say no strict liability. Next one, consent of plaintiff. What is this consent of plaintiff? Before doing an activity, let us take Rayland versus Fletcher only. Before constructing this water tank, if Fletcher had taken the permission of Rayland, if Fletcher had taken the full permission of Rayland, then obviously he has given a he has given a consent for it. So here Rayland has given a consent. So obviously he cannot file a case. Strict liability cannot be claimed. If it is act of third party, sir, how, sir, third party? Let us say the land was peacefully done. This construction and all was done. One fine day, there was a lorry which came from here, which came from the highway and caused an accident to this water tank, due to which all water came down and this water tank was collapsed into his land. Third party who is not at all related to these parties. Some third party, due to their activity, there was a damage. So obviously this party, this Rayland cannot be held, Fletcher cannot be held liable for this. So if it is due to natural cause, or if it is due to natural use of land, if it is due to consent of plaintiff, if it is due to act of third party, in case of statutory authorities, so in this case, instead of Fletcher, let us say Fletcher is not there. This was government. which has established a water tank for supply of water to public, and this water tank collapses, or due to this water tank there was a damage for Reliance land, government cannot be claimed for, because it is statutory authority for public service purpose. The land is used for public service purpose, so automatically strict liability will not come. Act of God. So one fine day there was earthquake, due to which this water tank collapsed. So again, Fletcher cannot be held liable. Plaintiff's own fault. So now one fine day what happened? Now this everything construction was there. Now Fletcher, this one Reland, what did he do? He was doing some construction work in his land. So while JCB was working here, JCB was working here. Accidentally, it touched the pillar of this water tank. It touched the pillar of water tank, and water tank collapsed, which caused huge damage to this person. So in this case, damages cannot be claimed from Fletcher. These are the situations where strict liability cannot be exercised. Is that clear for you? Yes, my dears. Strict liability is one of the important concept in your tort chapter. Is it clear? I want a confirmation from everyone. Only then I'll be proceeding now. Yes. Is there any doubts there? In case of strict liability, do you have any doubts? Super. Next one is vicarious liability. When person other than tortfeasor is held liable for a tort committed by other person, it is called as vicarious liability. Very simple area. They have given it as type of liability. It's not actually type of liabilities. It is just different areas in tort. So specific liability is one part. Vicarious liability. Even vicarious liability can be considered as a specific liability, because no mistake of that person, his agent is doing, or his principal is doing, but still the servant is doing, but still principal has to face the consequence. So once what happened, there was a law consultancy firm. Madam Angel visited the law firm to settle a land dispute which is between her family. Now the clerk of this law firm, what did he do? He asked the sign for Madam Angel. He asked the sign of Madam Angel for some legal documents. And using that signature, he transferred the property to him. He transferred the entire property to himself. That means he has committed a problem here. He has committed a fraud here. But the law firm will be held liable for the activity of this person. Reason being, the result is vicarious liability. The reason is vicarious liability. Due to vicarious liability, the act of a agent or act of a servant will make the principal, the master, liable. This is what vicarious liability is all about. So it is not essential that employer himself should be the tortfeasor. Even for the employee's mistake, employer will be considered as liable. So this is one small part of vicarious liability. So there they say, in case of independent contractor, whether vicarious liability, question will come in case of independent director, whether vicarious liability will come or not. Independent director means an outside party who is only related to only related to you with respect to some project. So agent is not that way, or your employee is not that way. You are holding a control on them. But independent contractor is not that way. You don't have any control. You only have a contractual relationship. So in this case, whether vicarious liability will come or not. Now in that situation, three things are to be answered. Whether you have appointed them specifically to carry out some tortious activities. That is to be seen. That means if the activity is done as per your guidance, then obviously you will be held liable. Second one is, if that independent contractor was totally negligent and you did not take care of it, if he was totally negligent, even in that case, you will be held liable. And for in case of strict liability, you will be held liable. Other than that, for the activities of independent contractor, you will not be held liable. For his act, you will not be held liable. In the course of duty, in the course of doing some contract activities, if he does some mistake, You will not be held liable. So let us say you have given the work of construction to a contractor. He will be looking after everything, cleaning your land and everything. So he cuts a tree which has come from the parallel, the adjacent compound wall. He cuts without permission, and that party files a case. Now you will not be held liable. It was his mistake. You did not appoint him to do that. So obviously it was his mistake. You will not be held. There is no vicarious liability there. But if that activity was done by your agent, or if that activity was done by your servant, in that case, obviously, vicarious liability will be on your head. This is vicarious liability. Next is against personal safety and freedom. What are the possible torts? They have given a list of torts which we need to understand. So first one is battery. What is battery? Use of force on a person without his consent, without lawful justification. So you see a person crossing the road. At the same time, you see the bus is coming very fastly. You want to save him. You go jump and push him. Later on, he says, why did you push? You have come against my wish to walk freely. So I'll file a case against tort. He cannot file, because in this case, there was a justification for you. You did it for saving his life. But you go to a person randomly and start pushing him. External use of force. This will be battery without justification. Even if you touch another person, it need not be, that is what they say, it need not be very forceful, or it need not cause any harm to him. But if it is like violating his legal rights, then obviously you will be charged with battery. You will be charged with battery. Use of force on a person without his consent. You can see here, people are fighting. This person is going to hit this person. So this is a battery. This person is pushing this girl. So this is a battery. This lady is slapping this person. Even this is a battery here. Everything are cases of battery. Battery means use of force on a person without his consent, without lawful justification. Next one is assault. Battery and assault, are they same, sir? No, but they are related. If you have to do assault, obviously you have to do battery. So if you are going to hit some person, if you have to do battery, you have to do assault. Whenever you do battery, obviously assault will be there. Reason, so you are going to hit a person. So what is assault? First I'll explain, then you can understand it. Creating fear in the mind of a person that he is going to commit battery. Here no contact like battery. Battery means there is a physical contact. You are pushing some person, you are hitting some person, you are smashing some person. That is battery. But assault means you are creating a fear. You're going and standing in front of him like hitting. You are raising your hand, so that you are causing a harm. You are causing a impact that you are going to assault him. You can see here. Or you are abusing him. You are abusing him. Even abuse will be called as assault. You are abusing, hurling abuses, intolerable abuses. That will be called as assault. You are pointing a gun at him. You are trying to shoot him. You are not shooting him. If you shoot, it will become crime. It is criminal. You are threatening him with a gun. That will amount to assault. See, this person is using spanner to hit him. He did not hit it. Once he hits, it becomes battery. Before he hits, the action is called as assault. This person is showing the punch. He did not punch him yet. This is assault. The moment he punches, it becomes battery. The moment he punches, it becomes battery. Only in one case of battery, there will be no assault. If someone comes and hits you from behind, from backside, if someone comes and hits on your head, or hits your back without giving a clue, that will be like battery without assault. In all other cases, there will be assault in case of battery. Do you agree with me? Whenever there is a battery, there should be an assault. Do you agree with me? Except in one case, when someone comes and hits from behind. Do you agree? Assault means causing a fear that you are going to hit. Battery means hitting, literally. Yes. Next one is false imprisonment. Blocking a person from moving anywhere. Imprisonment doesn't mean you are putting to jail. Even if you are blocking the person, see, in this case, these two are going and this person is dragging them. He is stopping them on midway. In midway, he is stopping them. You are you go to your neighbor's house and lock their gate. not allowing them to come out of their house. You block a person like this, you put a ring and you block him. All this will be false imprisonment, imposition of total restraint on liberty of person, even if it is for small amount of time. There is no restriction that it should be for this much amount of time. Even if it is for small amount of time, it will amount to false imprisonment. If you are blocking a road, so there is an accident now. There is an accident. You are not allowing the person to go. You are blocking. You are going. You are taking your bike and you are blocking him. It amounts to false imprisonment. That person can file a case against you. That means you have the right to move freely everywhere. You have the right to move freely everywhere, as per Constitution. Now, if someone is causing you legal damage, see, false imprisonment, there is no physical damage. In case of assault, there is no physical damage. But in case of battery, I agree, there is physical damage. Damnum sine injuria, injuria sine damnum we are speaking about. Here, damnum is also there, injuria is also there. In this case, in case of battery, there is damage as well as injuria. Damnum is also there, injuria is also there. In case of assault, only injuria, there is no damnum, but still it is a tort. In case of false imprisonment, there is no damnum, only injuria, but still this is a tort. This is a tort. Next, malicious prosecution. You are filing a case against a person falsely. You are filing normally criminal charges. You are going to put a false case on that person, and that person comes free out of the charges. That means even after you filing a false case, he comes free. Let us say a lady has put a dowry, a harassment case on a person. Harassment case has been put on one person, and on that ground, police have filed a case against him, and inquiry is going on. After the inquiry, he comes free out of it. The court says that he did not commit. There are no evidences. Now he can file a case of tort. Now he can file a case of tort. That is malicious prosecution. So malicious prosecution means you putting a false case on another person. He can put a case of tort under law of tort only when he comes free. Only when he comes free out of it. So in instigating judicial proceedings against a person maliciously and without reasonable cause, it should terminate in favor of innocent. It should come to an end. The prosecution should come to an end in favor of innocent. So that means if Shalu files a case against Lalu for harassment, if Shalu files a case against Lalu for harassment, the immediate thing is case will be registered, because that is the law. Once a woman complains of harassment, obviously the court law has to recognize and case has to be registered. After that, inquiry will happen. During the time of inquiry, they come to know that he did not do any harassment. Actually, he did not even physically meet her. She simply filed a case against him just to extort some money or something like that. So court gives him a clean chit. Once he comes clean chit, see, there will be loss of damage, for loss of reputation for him. Maybe newspapers might have reported against him. There are a lot of media news. You know what is happening now? Media, even this much small thing, they are doing such a huge thing. In fact, I will tell you, if at all these drugs things and all, I'm not in favor of anyone here. I'm not in favor of, but I'm trying to tell you what happens in all these drugs cases and all. If at all those actors come free out of the charges, if they are given a clean sheet by the court, if court says that they are free, they did not do anything like that, then they can file they can file a case against all these news media channels under law of tort, because it is malicious prosecution. So medias, why they can file a case? Because they have caused defamation, for defamation purpose. For the person who has registered a case of drugs on them, for them they can file malicious prosecution case, and on them they can file malicious prosecution case when they come free. So that is important. Just because you filed a case against another person, that person cannot file a case under tort. He should come free there. It should result in damage to his reputation, personal freedom and property. Either he should have been detained, put into jail or something like that, or his property might have caused some damage. People have pelted stones or something like that. It have caused a lot of damage to his reputation. He might be a respectable person in the society, and that has caused a lot of damage to his reputation. He can file a case in this case, in this situation. Next is nervous shock. Nervous shock, it is not about mental things, it is physical. Impact of mental things. See here, he is harming himself. He is cutting his hands. This guy is cutting his hands. Why? See, let us read. Physical injury through what the person has seen or heard. A person might have heard something shocking. A person might have seen something obscene. A person might have seen something which is very much affecting him, due to which he is causing himself a physical harm. Then obviously it will amount to tort. Those person who has caused this physical injury will be brought under the law. There should be some injury as a result of emotional disturbance, fear, or sorrow. There should be some disturbance. Maybe that person is not agreeing to go out of the house only. Even that is possible. Even after seeing some incident, that person is not even ready to go outside the house. So this will amount to nervous shock. Obviously, it will be treated as a tort. Because for all these things, there is no specific law. There is no specific law. This will all be covered under tort, and court says that yes, other person's right have been disturbed. So he has to be protected. For that purpose, court orders some compensation. Next one, defamation. What is defamation? Defaming someone. How? By words. Publication of a statement which tends to lower a person in estimation of right thinking society, or tends to make him shun or avoid them. So you are making some remarks on your friend such a manner that the entire friend circle is going to expel him totally. They are like, no, that person is not good. You have done some derogatory remark on him. Now obviously he will be very much affected. His reputation is affected. Rational society is going to think wrong about him. So automatically he can file a case against you. Here nothing to prove. Whether the things which you said is true or false is not relevant for us. If he is hurt by that, if rational thinking society is thinking wrong, then obviously that person can file a case under law of tort. So defamation can happen in two ways. One is libel, one is slander. I have given you the photos of social medias. See, representation in the form of permanent, written, or videos, movies. You are creating video clips which will cause defamation of different persons. You are writing an article, you're publishing it in online, you're publishing it in some newspaper. It is permanent one. Once it is recorded, it is permanent. Deleting options, everything is there. That is different. But once it is written, it is record. It is a record. Today, nowadays, it is a zaman of screenshots. People will take screenshots. So obviously, it is a permanent record. So whatever it is, people will take screenshots. Even if you write a Twitter for 2 seconds and you delete it, people will take screenshots and use it against you. So this, once it is written, once it is recorded, once it is published, it will be called as defamation. Libel is more dangerous than slander because libel is permanent. So the consequence of libel is more grave than slander. Slander means what? Defamation through spoken words. See, a group of people are defaming this person and he is so worried about it. Group of people are causing defamation against him. They are telling their boss about him, something wrong about him. This amounts to defamation. So in case of defamation, again under law of tort, and again in India, see, defamation is a tort worldwide. In India, this is a criminal activity. Indian Penal Code section 499 recognizes this as a criminal activity. Indian Penal Code section 499 recognizes this as a criminal activity. So this is about tort which can be caused for an individual. Tort or wrongs to personal safety. Next one is remedies in tort. What are the remedies? So wherever there is right, you have remedy. So in case of tort, what are the remedies available to you? Judicial remedy. You can go to the court of law, file a case, get damages. So your reputation is lost, sir. Court will decide some amount as damages to you. Court will ask the person who has caused this one to give you some damages. Injunction, stay order. If someone is doing an activity which is against you, someone is going to publish an article tomorrow which is defaming you, and you come to know about it, you go to the court of law and bring an order of injunction. Go and order of you go to the court of law and bring an order of injunction. So you are asking the court to give a direction to him to stop it. You can get that. Specific restitution of property. Someone has caused a damage to your property, restoration of property. Even that can be done with the help of court. These are the judicial remedies available in case of tort. What are the natural remedies? What can you do as you on your own? What can you do? See, you can see here. This person went to attack on, this person was about to attack this girl. She slapped him. Self-defense. She slapped him. That is self-defense. And it is allowed under tort. If you do something for self-defense, again mens rea, you did not have any intention, but you are doing it as a response. You are doing to safeguard yourself. So this is possible. You can act, you can do self-defense activities. Prevention of trespassers. If someone is trying to come to your land, you can stop them. You can be there at the gate and stop them. You can ask them to go aside. If they are pushing you, you can push them back. Of course, where it is justifiable. Some drunkard is lying in your property and he is causing a disturbance. You can lift him up and you can put him outside. Possible. These are possible. So prevention of trespassing. Re-entry on land. You are expelled from your own land. You are expelled from your own property. You can come back to your property. You can come back to, because that you have the right there. So you can come back. This is also a defense available to you. Recapturing of goods. Your goods are named in some other parties and has been delivered to him. Or someone is holding your property. Someone is exercising the lien on your property without any justifiable reason. Now what you can do? You can ask him to give back. You can take the goods and come back. Recapturing of goods. It belongs to you. He doesn't have any grounds. He doesn't have any grounds to keep them. So you can take back the goods and come. Next one is abatement of nuisance. Abatement of nuisance. So what does this abatement of nuisance means is, if someone is causing damage to you, 1 second. Okay. So abatement of nuisance. So if some abatement means making changes. Abatement means making changes. If someone is doing something bad to you, you can ask them to stop at least, right? You can ask them to stop doing those things. So that is also a defense available to you. Next is distress damage pheasant. Abatement nuisance. Another example I can give you. Let us say there is a poisonous tree. Your neighbor has put a poisonous tree, or your neighbor's tree is such that, your neighbor's tree branch is such that it is touching the electric lines which is passing in your property, that may cause a damage to your house. Now what you can do? You can abate it. You can change it. How? You can cut the trees. You can cut the branches at least without.
A very good morning to everyone. Sir, shall we begin?
Yes.
So very good morning to you all. Dear students, you all have completed your graduation and now you're at the point of your life where you need to make decision for your career. And CA is one such career which is usually preferred by commerce students. So dear students and parents, welcome you all for the orientation of CA Intermediate Direct Entry Route. I request Meghna, our coordinator, to introduce our speaker for the day, CA Gopal Krishna Bhai.
Good morning, sir. Good morning, all.
Good morning.
Okay. We have with us an eminent speaker for this session, CA Gopal Krishna